The process comes to page 8. Then this DPC was conducted to compile losses the merit of all these four institutions. And this is the losses findings of the committee. Then losses will find at page 12. This is on merit losses. The number one losses David Cluster Therma LDC.
No, it's okay. Let's come to page 7.
Page 7.
So who is roll number 22?
22 is losses for export keeper.
Okay. 33?
33 also is export keeper.
No, there was something you brought on record in the selection list. Where is that?
See the page 7 also. Here also you'll find this is the selection list.
Just a moment. Your affidavit, you have brought on record certain marks. Where is that? That so and so got so and so marks. So and so got so and so marks. That
Page-
select list type, marks, select list.
Page 19.
9?
19, 19.
1 9. Of your affidavit.
My opinion.
Affidavit, दूसरा करके रखा है, क्या दिक्कत? One 9. Okay.
In 4 centers it was conducted.
So now you have that affidavit with you. Now
Yes,
show
yes.
me roll number 33. What is your roll number, Mr. Sona? I don't. In this page 19 onwards, where is your name figuring?
19 onwards. My lord will find page number 25. Serial number 1 is the petitioner number 2.
2.
Yes.
So
Then my
this is the end of the matter. This is the select list. That you have. This is the select list.
Close.
Huh?
Close.
So the roll number of petition number 2, Jaco Lego,
no, my lord. Petition number 2, Rigam Ribba, page number 25, my lord.
25. Jaco Lego is who?
This is not the petitioner, my lord.
Is not.
Not my lord.
Okay. Page number 25.
Serial number 1, Rigam Ribba.
No, roll number 20. Roll now you are 4009.
9.
4009. And the second one?
Serial number 4, 3384, petitioner number 4.
3384.
Then, my lord, next page, page number 26.
No. This is again jumbled up.
Okay,
This is
what
not-
I'm trying to point out.
This is not in terms of merit.
Losses, if see the page 7.
Hmm.
Here losses.
Serially, it has been given.
Descending order loss it has been given.
Ascending order.
It's very ascending one. It's very apparent on the losses very close. So what we are pointing out is that selection losses, these was published not in losses on merit.
So where is that merit list?
No, this is the losses final.
This cannot be. This cannot be. Why I am saying so?
No.
If you come to the rules holding the bill, Mr. Sonar has brought that on record,
My lord.
come to the rules. The rule 80, suppose. So there is no doubt that you have adopted these rules, secretariat rules for the water resources department also. So now come to 18. Candidates for appointment in so and so shall be appointed in order in which their names appear in the relevant select list, subject to reservation so and so, so and so. So the appointment order has to be in terms of Rule 18,
Close, select.
right? Now you come a little bit ahead. Rule 14. Appointment may be made from select list in order which the name appears in the list, provided that a temporary appointment for a period not exceeding 2 months may be so and so, so and so. Now, how do you prepare the select list is in Rule 11.
Lordship, to my understanding, so
Hmm.
when we talk about the rule 11,
Hmm.
select list has to be prepared also on merit laws.
Because what I'm saying so, because here you had a selection in 4 places.
Four places.
The committee which is there, constituted here, say a similar committee maybe you have constituted. You have not produced on record the markings given by the committee members. What you have produced is just a document wherein the signature of the chairman is there. Where is that person? Who is he? When was he appointed? How was he appointed? Who were the other members? Nothing has been disclosed.
Lordship, so far this.
Because you will have to, even if you prepare a select list on the basis of your this ascending order, you will have to have a select list at your possession. That these are the persons recruited. That is the need of the rules. If not, we will follow 14 and 18 and hold that the appointment order is in order of merit.
No, here, Lordship, what I'm submitting, the marks obtained by the Lordship petitioner is not being disputed. That's not issue here. Also.
No, it
And
cannot
marks
be.
obtained by the private
So,
respondent
Patin-
are also
But in subject to correction, whether it has to be disputed or not, this situation has not arisen because you have not produced on record cogent materials. You have just brought something.
No, that is there, Lordship.
You have brought something. Okay, where is this file? Okay, where is this file? IFC 1196/2001. You have it? Give it.
The marks Lordship is given in the second file.
Okay, let's see how you have made it. This is 9. Where is the note sheets of 2002?
2002 Lordship.
This is nothing, just a bundle of papers. Not even the original signatures.
It's there, Lordship. And it's the
No? '58 to '79 of file number 119/2001. Where is 119/2001? Okay. It was different committees holding the meeting, selection process. Right?
Lordship.
What are your roll numbers? What are your names? Petitioners?
The petitioners' names are, my lord, Tagedon,
Roll number?
my lord, I'll just,
Tagedon.
my lord,
Okay.
Tagedon, then Rigam Riba,
Rikam?
Rigam Riba,
Hmm.
4009 roll number. Then, my lord, Nita Tapak,
Nita?
4142 roll number.
Oh.
Then Mapek Rina 3384,
3384.
my lord. Then
Just a moment. That is not even a second. Oh, yes, a departmental selection. Okay. What is this APST departmental selection?
So if this, then we held those 14 districts. And this is, it was divided to one each district also. And for central pool loss, another 4 loss post was kept also.
Okay. So what was the mark obtained by Mapek Rina?
Loss
3384? 3384 marks.
The mark, it was 215.5.
215?
215.5 mark obtained by Mapek.
And she is a petitioner.
yes,
And what position has been assigned to her in the select list? In the
in the select list, my lord,
in the gradation list?
gradation list, my lord,
Mr. Tapin, kindly do a small exercise.
99, my lord.
Kindly do a small exercise for us. You have this page 4.
Page
4. If you can ask your office, they'll just type out this 4 and 5 till Mamuni Rian and just put across their names the marks code.
Mark. Secure by them.
Secure price. Okay? You can have it tomorrow?
Tomorrow, day after tomorrow.
Day after tomorrow. If the marks, because Mr. Mr. Sonar, I was with you. Because it was only this that was shown to us. But Mr. Tapin has produced the records. What has happened here is that there were different boards holding this election. Thereafter, there was a committee constituted to normalize all those things. Compile, normalize everything. That committee then complied with it. And then they have prepared a select list. But they made a mistake in all probability, subject to what list Mr. Tapin will produce. While publishing the select list, they did not publish it in terms of the marks code. They published it in the ascending order, 33 to 6,000 something.
As on today, this select list has not been published.
It's on record. We'll have to see if there is something on record already existing. We can't go beyond that. Because you also, 2002, you came up, this issue came up, this gradation is of 2009. You instituted proceedings before this court in 2015.
Because till that time,
You did not know, be that as it may. So we'll have to give it an answer. Because I was with you because of Rule 14 and Rule 18. But Mr. Tapin's that list shows this is a select list. At least we have a document here. And it's there in the record also. So, be that as it may, these are the people's appointed. And these people were appointed from this list. Here I find 22, 33, 35, they have gone serially. So what is that background? So that background, what is there in the record, we can only go. Because otherwise you will have to dispute your marks, which you can't at this stage, and you have not done also.
Yes.
If Mr. Tapin shows us that list and that list merit position confirms to the position given in the gradation list, we will close the
My
reputation.
question here is, my case is like, because as of today, my case is that select list, they have never published. Number one,
Mr. Sonar, for that we are examining the records.
Yes. Not published. So all this for 7 years, madam.
So if there is no select list published, how were you appointed? We will interfere with all the appointments.
That's appointment letter, madam. That appointment letter, my lord, because rule says my lord has seen.
See, they have brought on record these materials. Rightly, wrongly, they have brought on this compilation before us. You have not disputed this.
Because it was never available to us. Even
No,
though
no,
part of the
affidavit, you have not got the affidavit.
affidavit I have got.
That's the
Select list,
affidavit.
select list,
No, the marks, it's there.
mark is there.
Then I can close it today itself.
My lord, my case is my lord like this, my lord. After 7 years, my lord, can they change can they come with the, my lord, saying, my lord, that your merit,
Provided before 7 years, they have not done that. If they have done what they are projecting today, then they can always stick to that.
here is the question, my lord. As on today, my lord, those who are the recruitee of 2002, 2009, all those earlier recruitee, my lord, they have maintained that those select lists as per the, my lord, appointment order.
Oh, I got it.
So now only for us.
Mr. Check up.
they
And we are closing it today. So wait, check up. Devi Prasad Sharma. 1, serial number, roll number 4344. Is he the merit position number 1?
Yes.
Huh?
Yes.
Malizan Begum, 240, roll number. Right? Sonu Lama.
Yes. Third was.
Huh?
Sonu Lama third.
Ah,
And Pramod Kumar Sharma is at fourth.
4th. Okay. Sunil Nair, 5th. And those 4 extra candidates who were there.
Like
Last-
that was the laws you will find.
No. Last 4 candidates that extra names were given. Departmental selection.
Oh.
Just find out in the origin, the other file, main file. Departmental selection. The record which I returned to you. Departmental selection. Departmental selection, have you got it? Departmental selection, that two pages wherein the list has been given.
Yes.
No.
Yes.
Department, what is the name?
Mapik Rina, Lota Mosa.
No, give me the roll numbers. Mapek Rima roll number is not there. 1, 2, 3 for Mapek Rima. Where is Mapek Rima in the gradation list?
99, my lord. Page number 49.
99. Mapek Rima, then the next name is?
Joseph.
Next name? Mapek Rima?
Miss Lota Mosa.
Lota?
Lota Mosa.
Mosan. Okay. Then
Then Mani Nimpa.
Mani
Nimpa.
Lingpa. Okay. You come to page 66 of your writ petition.
66.
No need of that list.
66, my lord.
So this corresponds to that file.
Yes, my lord. I have made it, my lord, considering their given.
So even if that is the position, you have not disputed that position.
My lord, I have.
2 baje. 2 o'clock. We'll pass orders. Just give me the that files along with this. I'll just have a look. 2 o'clock we'll pass the order.
I have certain more submission to make, my lord.
For the other court. I was with you. I told you I was with you. But they have done that exercise. I can't go beyond that. Because you have not disputed that. Next time, better case. Yes.
Item number 2.
Yes, Mr. Sona, what is this?
Here is also case, my lord.
Oh, that one. Horticulture.
My lord.
What is left? The report has come.
Inquiry report is.
You were given the maximum number of works.
My lord. My lord.
You did not do it. They gave it to somebody else. They have done the works. Everything is satisfactory. No. The execution of the works, maybe there was some default that they were selection, there was some, but you have not questioned that while executing the works, they have committed any discrepancy. The authorities say work was executed in the manner required and the amounts were also disbursed.
At the time when the petition was filed.
And you have not brought on record the fact that the works order contracts that were given to you were terminated.
No, my lord. There was a subsequent event.
That also you have not brought on record.
That because my lord is something like
Because here you say that you were not even given any work. That's the projection, the
that is not
repetition.
my case.
You come on, I'll show you.
That is not my case, my lord.
You come to para 11.
Yes, my lord.
My case is like this, my lord. Here is the, my lord,
I got it.
board
There is a
finding
guidelines.
verification of the board, my lord. This all private respondent, they don't have any SOP. Question is like that only the SOP, existing SOP is my SOP. So under this DPT, that the benefit has, this money has to be transferred directly to the, these beneficiaries under DPT. Thereafter, the beneficiaries will avail the necessary inputs from the available SOP. Here is the case in the East coming district. Not a single SOP exists, my lord. Only my SOP is in existence. But the
Now show me that scheme that the money has to be transferred to the person concerned, then the money.
My lord. My lord, kindly turn to page number 17, my lord.
Okay.
Guidelines is given 3, serial number 3, my lord.
Hmm.
DBT should be exclusively compiled and fund transferred to the beneficiary in respect of other seeded bank account as per DBT guidelines and instructions circulated so and so. The sanction amount should be transmitted to other seeded bank account of beneficiaries by DBT made only after complete delay, so and so. So here is the case, my lord. What the respondent authority did is, my lord,
They gave it
they
to the
supply order
parties.
to the non-existent source, my lord.
Okay, fine. But you were also a beneficiary to that.
But my beneficiary is something different. But
Why did you take it?
oh, my lord.
What I understand is that the money, say to buy some implements, the money has to be given to the concerned beneficiary.
Yes.
Then it's up to the beneficiary. He goes to you, goes to him, goes to whom, then buy it.
Yes.
Like
yes.
we have a money, we may go to Shawam, we may go to somewhere else.
Yes, yes. No
Right?
issue. No issue.
Now, in this case, you are also given work orders. You also made supplies.
I have not done any supply work.
Whatever as it may, you have accepted that order.
No, my lord.
And your case that why supply orders are issued. Supply orders should not be issued.
Yes, yes.
That is not your case.
No, that is my case, my lord.
Show me.
That is
Show
my
me,
case,
show
my
me.
lord. That's why I challenged the supply order, my lord. My lord, kindly see the my lord.
That is after your thing was cancelled.
No, no, no. Till that time, it was not cancelled, my lord. My lord, my prayer, my lord.
You come to page para D, prayer number D.
My lord, this my prayer is that.
Mr.
the
Sonar, explain this prayer.
Yes, my lord.
Hmm.
Commanding excludes recommended name. Why recommended name is, my lord? Because there
For
is only
supply
one.
of, to supply, firm for supply of various so and so to the beneficiaries under so and so.
Yeah, may I explain, my lord? It is something, there is only one SOP, my lord. So it is the duty upon the respondent authority to inform the beneficiaries to get the inputs from the available SOP. Now the question here is, my lord, when there is no SOP, and what the respondent authority did is, my lord, they
just issued the supply order. Thereafter, they are saying that they have done. My lord, kindly turn to my lord, order dated of this honorable court, my lord, 27/3/2018, my lord.
Just-
As on today, even no affidavit has been filed by the, my lord, this respondent number, government department, my lord. As on today, no affidavit has been filed.
Have you challenged the inquiry report?
Inquiry report, my lord.
Yes.
Lordship, the inquiry report is very clear.
No, his contention is why these tenders? Why these supply orders? Because it has to come from the beneficiary. It's up, you pay the money to the beneficiary, let the beneficiary go anywhere. Why have you issued the supply orders?
Lordship, that currently supposed to supply.
You have not read the inquiry report.
Yes, I have gone through the inquiry.
Then see the statement of Rumro Sorum.
Showroom.
Hmm.
Stated that supply orders was issued to 11 firms based on recommendation of the boards. And as per provision of guidelines, implementation issued by the Commissioner of Horticulture Government, then it was released, right? And Lordship,
Why? Why? As the beneficiaries express the inability in procuring the inputs by themselves and authorized so and so, and accordingly inputs were procured and issued for distribution to Excel through field beneficiaries. Okay, anything more?
basically, Lordship, normally all the beneficiary through the firm, they connect to the beneficiary with. So all the.
It's the other way around. It's the beneficiaries who have to be paid
Yes, Lordship.
and the beneficiaries will go.
Supply order and they have been paid. And it's already been paid. Respect, inquiry report has stated that respectively, all the firms were, accordingly, the payment was made to the respective beneficiary by bank, bank transfer.
Hmm. Where it is given? No, it is given to the firms, not to the beneficiaries. And where is this office memorandum? 23/5/2017, it's on record.
23. 23/5 is not on the record.
No, it should be.
No, I mean, it's not in the record.
Mr. Sunar, now that everything has been done, what we do is we accept the inquiry report, close the matter. However, we provide that in future, under such, in view of the scheme which is there, the authority shall strictly adhere to that. And we'll close the matter, right? नाम लिख लीजिए बस 2 बजे एक बार सेकंड हाफ को दो बस सेकंड हाफ को second half I'll pass the orders. Because if I start passing orders now, no matter can be touched.
It will take 5 minutes, my lord. That's all.
Show me one thing, Mr.
My lord, just kindly, my lord would hear me for 3 minutes.
Yes, yes, sure.
Petitioner was a retoucher in Department of Printing. It was fourth pay commission at that very point of time when he joined the department, and the pay scale was 1,400 to 2,300. Now, when the fifth pay commission report came with effect from namely 1/1/1996, my lord will remember. Now, the fifth pay commission had three parts: Part A, Part B, Part C. Part A was for general, in general, all categories. That means pay scales were given and their revised pay scales were given in terms of the fifth pay commission in the Part A. Part B and Part C were meant for specific categories. Now, this petitioner was given the benefit under the Part A, namely the pay scale of 1,400 to 2,300 became 4,500 to 7,000 under the Part A. He got the benefit. There is no quarrel with that. But what happened? This petitioner insisted that he being retoucher, now retoucher, my lord, in the printing press, it's a job of a skill, but it's a skill job. But then in the Part C, there are a specific post. I will show that. The specific post of retoucher is for the printing press of the Government of India at Nasik, where the currency notes are printed.
No, it is for Hyderabad.
Hyderabad, but Nasik is also given.
Nasik has not been included.
Hyderabad, anyway, I'll just be that. So it is for a specific post. So there the pay scale was 5,000 to 8,000. And when the writ petition was prepared, it was based on two premises. Number one, he is entitled to get the benefit of the Part C, and that Part C was also accepted by the state of Arunachal Pradesh. The second premise being that there were certain other officials who were also given the benefits under the Part C, and even though they had the pay scale of 1,400 to 2,300, they got the benefit of the pay scale of 5,000 to 8,000. Now, so far as the first premise is concerned, it turned out to be incorrect, because the government of Arunachal Pradesh in its affidavit has made absolutely clear, we never accepted Part B and Part C. It was only Part A which was accepted. Now then the petitioner started saying that he will be able to get the evidence showing that who are these officials who were given the benefit of a higher pay scale of 5,000 to 8,000. But till date, he failed to furnish any. So therefore, my lord, in view of that, my simple submission would be, I don't know in future if he can do that, God knows, possibly he may not be able to, or he may be able to. If he is able to, since in any case there is a doctrine of continuous wrong in the matter of the fixation of pay scale, he may always come before the honorable court. So, my lord, the petition may be closed only with an observation that as and when in future, if he gets evidence of this nature, that other officials were given the benefit of the higher pay scale of 5,000 and 8,000, then he would be at the liberty to approach the appropriate authority with a representation giving that evidence. If he doesn't get a relief, he can always come before the honorable court.
What
that is all.
evidence he has not got from 1997.
We will try. No, but that is it.
We will
Sometimes
heard Mr. P.K. Tiwari, learned counsel for the petitioner, also heard Mr. S. Hatin, learned counsel, appearing for the state respondents. The petitioner in the present proceedings has raised a grievance with regard to the manner, with regard to the revision of pay as affected in his case in pursuance to the adoption by the state government of by the government of Arunachal Pradesh of the provisions of the Central Civil Service Bracketed Revised Pay Rules 1997. The case of the petitioner is that he being holding the post of retoucher in the government press. What do you call that? Government press. Government press at Arunachal government press.
Directorate of Printing now.
In the government press under the Directorate of Printing, he is required to be authorized the revision in accordance with Part C of the said rules of 1997. And accordingly, his pay is to be revised to the scale of 5,000-8,000, and consequently, by reckoning the set revised scale as authorized, as prescribed for the post of retoucher, his pay accordingly is to be revised. In accordance with the revision of pay, so coming into force upon the recommendations of the 6th Central Pay Commission and the 7th Central Pay Commission. What's up? the said grievance as raised by the petitioner would not require any further consideration by this court inasmuch as it is available brought on record by the respondent authorities that the government of Arunachal Pradesh, while adopting the Central Civil Service Bracketed Revised Pay Rules 1997, had, via an office memorandum dated 23/10/1997, adopted the same to the extent of the scales as notified in Part A of the first schedule of the said rules of 1997 and had categorically notified that the scales of pay as notified in Part B and Part C of the first schedule to the said rules would not be applicable to the government employees of the Arunachal Pradesh. So, in that view of the matter, the provisions of Part B and Part C not having been adopted by the respondent authorities and it being a settled position that the manner in which a pay scale is to be revised being one of an executive function, this court in exercise of its, this court would not have the expertise to examine, to hold that the petitioner would be eligible to a particular scale of pay, although the same has not been adopted by the government, although the same has not been prescribed by the executive, by the government for its employees. So, in that view of the matter, the notification dated 23/10/1997 not being under challenge in the present proceedings, this court is of the considered view that the relief as sought for by the petitioner in the present proceedings cannot be entertained, and accordingly, the same would stand dismissed. However, considering the grievance raised by the petitioner and also the plea taken in the proceedings that the Part A and Part B scales of pay, Part B and Part C scales of pay were authorized to certain category of employees in the state, it is open for the petitioner hearing to approach the respondent authorities by within a respondent authorities highlighting the above position and also staking a claim for being extended with the said benefit, with the said benefit. Full stop. Will do.
Yes, that's all. But what else in a case of this nature?
Look, I don't know, only non-payment of solicium and interest, Malad, in the conflict.
Mr. Nabam has to be heard fully.
Notice to be
That I can do.
already 1 o'clock.
Yes, Mr. Nabam,
My lord,
6 weeks notice.
my lord.
Oh. Heard Mr. T. Patil, learned counsel for the petition. Also heard Mr. M. Kato, who is appearing for the state union. Mr. Kato is here. You are
Yes,
here.
no, he's for highway.
Mr. M. Kato. Mr. M. Kato, you
Yes.
heard Mr. T. Patil, also heard Mr. M. Kato, learned counsel appearing for the respondent, Deputy SGYI. Also heard Mr. R. Namam, R.S. Namam, learned additional advocate general appearing for the
4 and 6.
respondents number 4, 5,
4.
and 6.
No, 4 and 6.
4 and 6.
Yes, this-
Additional advocate general 4 and 6 nahi likhna. Push up. Comma. Also heard Mr. R. Soikia, learned counsel appearing for the respondent number 5. Push up.
5, 7,
Appearing for the
1, 2,
public department, standing counsel, public works department. Full stop. Issue notice, returnable 6 weeks. Mr. Kato accepts notice on behalf of respondent number 1. Full stop.
1, 2.
1, 2, I don't think so. It's a company. Full stop. Mr. Naba, learned additional advocate general, accepts notice on behalf of respondent or Miss R. Pangu, assisting Mr. Naba, accepts notice on behalf of respondent number 4 and 6. While Mr. R. Saikia, learned standing counsel, PWD, accepts notice on behalf of respondent number 5 and 7. 5 and 7, 2 are there. 5 and 7. What's up? No formal notice is to be issued. However, extra copies, requisite extra copies of the writ petition be furnished to the Learned Standing Council for the respondents within 3 working days from today. So, sir,
Already
petitioner to
served.
take steps for service of notice upon respondent number 2 and 3 by way of registered post with AD. Steps within 3 days. So, sir, register to list this matter again after 4 weeks on a date to be fixed by it.
My lord, requisite copy, my lord.
No, I've already told.
Yes. Obliged, my lord.
But Mr. Patin may not give you.
My lord, we have already served extra, already. Here also we have taken the record.
The brief is very heavy.
Very
So
heavy.
beforehand, copies have been served.
Obliged, my lord.
Let's see how we can go. थोड़ा list आगे कर लेता है. थोड़ा list कर लेता है. उसके बाद देखेंगे.
Item number 5.
Mr. Pramay, you are appearing for the department. They have made out a case. They were juniors, AFA juniors. They ought to have been promoted as seniors, which is having a higher scale of pay. You promoted them as assistant marketing inspectors. And in one of the orders of regulation, find that he is regularized as marketing inspector, but that is wrong. Now, his contention is his juniors have become AFA senior, drawing higher scale of pay. And in other districts, AMIs are drawing higher scale of pay. Get your instruction. We'll have it on Wednesday. Because he's on a verge of retirement. If he gets something, we'll give him.
I would pray Mel some time to file a detailed opinion Mel.
No need. No affidavit is called for. Only get me this clarification.
Instruction Mel
From your secretary. Just ask your secretary. Every case, there is no requirement of filing an affidavit. We believe Mr. Pramay. Pramay saying this is the fact, we will accept that.
No, Mel, in this case, I humbly believe the
You need not. You have your instructions.
affidavit-
We'll have it on Wednesday.
epidemic be required in the Mel.
No affidavit is called for.
Now, my lord has
This court is of the view that I can dispose of this matter today itself, but I want a clarification from you. Hardy Learned Council for the parties. On the next date of listing, Mr. L. Premi, Learned Standing Council, Agriculture, na? Agriculture Department shall receive instructions as to whether persons junior to the petitioners herein were promoted to the post of AFA senior and are drawing more pay than the petitioners herein. Also, Mr. Premi shall also receive instruction as to whether assistant marketing inspectors posted in districts other than where the petitioners are being so posted are receiving higher scales of pay than that authorized to the petitioner. The above information be received in writing from the Secretary, Agriculture Department, Government of Arunachal Pradesh, and be placed before this court on the next date of listing. List this matter again on Thursday. Give him one more day, okay? Why? If you get the money, you're happy.
Item number 6 and 7.
Director, General Police. Who is appearing for the police? You are appearing?
Yes.
Mr. Pramay, you are for the
private respondent Mel.
private respondent. Okay. The case of the deputy commissioner, or not the deputy commissioner, actually the commissionerate and you is that a particular parcel of land was given to the police department,
Mel.
which you say is 9,000 odd, right? But the documents that are brought on record shows that they were given 13,786. There is a document. So if that be so, how can you say that they were not given that much land? Because the very premises of that committee's report is wrong.
My lord, here, my lord, Undisputedly, my lord, in dispute, some relevant peg, my lord, is not brought, my lord. Now I have filed, my lord, I have brought that. My lord. Now, undisputedly, before this, my lord.
You don't have a land LPC in your favor. You're just occupying some land
No, my lord, yes, my lord.
proximate to the land of the police.
No, in between there is other settler also. My lord.
Huh?
Other settler is also there, my lord, in
Well,
between.
it is. It is up to them. If that land is theirs, they will have it. Yes. You are paying for the
ADC.
ADC. The ADC is not acting in the manner required. We are not confident. He has some other interest. That is what is being projected. What is being done. He was asked by this court to make an inquiry,
Yes,
right?
yes, yes.
How has he brought this 7,000 when the land which was given to that department, what was the department, first department?
Urban development.
Urban development was around 13,756. How can he bring it and say that only 7,000 was given? That is the basic premises.
Yes, yes.
Then have your instructions. How he has done it. On the next date of listing, the Mr. Lolin,
Why remember?
huh?
Why remember?
No, Mr. Riram shall receive instructions from the additional deputy commissioner. What is that?
ADC.
ADC which district?
ICR.
Itanagar.
Yes, sir.
How do you describe him? Additional deputy commissioner.
From chairman.
Comes the additional deputy commissioner, respondent number 4. Hmm. Where is that report?
Now, academic university connection.
As to how the land donated initially to the land allotted initially to the urban development department was so quantified at 79600 square meters, whereas the documents brought on record in the present that the land as allotted to the urban development department was around 13,980 square meters. So the instructions in this connection shall be received in writing from the respondent number 4 and placed before this court by Mr. Sriram on the next date of listing. List this matter again on Thursday. Just get that information.
Item number 8.
So then,
Ah.
but not safe.
Oh.
Not safe.
He has even filed an affidavit now.
Affidavit, by this affidavit, we can make out that not safe.
I only want to know. We'll forget all those things. If you are giving him some land, give him.
Not safe, this occupied land is 2,500 square
He is
meter.
only asking for 500 and I'm asking you, don't give him that land. Give him some alternative land if he is a landless man. That's all. That much instruction you take. Because anyway, an application is pending.
Application
That
is,
you have brought on record.
yes,
Hmm.
yes, we have said that we have received this instruction, but.
We will
because
not
Lordship,
go
it Cannot
into-
be given, that's why, Lordship,
Cannot be given.
that's why eviction has been served.
I'm not on that. Don't give him that land. Give him some alternative land. If he is a landless man,
Lordship,
that land is in his possession for a long time now.
Lordship.
Give him an alternative land of 500 square feet. Consider.
Consideration, Lordship, that much.
That's what I wanted
But
you.
it will be flat get, Lordship.
Huh?
It will be.
Don't give
flat
him
get.
that land. I'm not asking you to give him that land.
Lordship, understood.
That
Un-
parcel is not there.
Understood.
But somewhere he has to, because he is having that land for a long time. And his further case is that he had brought it from somebody. Okay, we will not accept that. But that's a fact. Right. You give people land in day in and in day out. Why not him?
Also with the declaration of smart city, land is scarcity.
Even
Patna, but
outside the city, outskirts of the city somewhere, within that district, the
not
deputy
very far.
commissioner.
Not very far. No.
Huh?
Yeah.
Give him somewhere else. I'm not asking him to give it when your projects are there. Somewhere where it is available.
Not
Right. Otherwise, he does not have a case. We can dismiss it. But a man has projected that he has got no other. You don't have any other land. Not even in the Bosti.
Everyone
Ah.
have lots. Everyone have.
Bosti you have. Then you will not get. What does your deputy commissioner say about that?
About-
No instructions have come.
No instruction.
Just have it. We'll have it tomorrow. Just have it.
Tomorrow.
Day after.
Day after.
On the prayer of Ms. Ethic, learned government advocate appearing for the respondents, list this matter again on Wednesday. Just have it.
Of lives.
But if he has Bosti Mati, don't give him. You come and tell me. I'll dismiss it.
Here, every individual has lots of land. Of lives.
Number 9.
Who is appearing for the government? Mr. Tapin. 50 lakhs.
So Ratan is coming. He's-
Ratan. Mr. We'll have it after 5 minutes. The additional advocate general is coming. We'll have it after 5 minutes. Moment he comes, just tell them. We'll call. कौन सा? हाँ? नहीं सीरियल लिस्ट खत्म कर लेते हैं।
Number 10.
हम्म,
Item number 10.
10. You are there? No, it's 10. Yes, Mr. Nama. No affidavit would be filed required. Their case is you have done your re-verifications, but you are not releasing the money. Why? And no affidavit.
I think we have filed a affidavit.
Affidavit filed.
Yes, my lord.
This is filed by NHIDCL saying that they have no role.
No, this
Oh, junior government advocate. Yes, this I missed out.
disaster management. they have filed.
Disaster management, DC. Yes, madam.
Disaster
Have you received this affidavit? What do you have to say?
Content number 1, 3, 7, 7, and 8.
Hmm.
That is the content.
They have not filed.
They have filed.
Then what more is required? That affidavit is there.
My lord, respondent number.
What is your case? What is your grievance?
Because it said after the re-verification they get done,
Hmm.
but not this way the contingency.
And what does they say?
My lord, and this story.
But where is the report? Fact-finding committee report is on record.
My lord, I'm very sorry to inform you that I am not the living counsel. The living counsel is actually out of station.
On the prayer made on behalf of the learned counsel for the petitioner and not objected to by the learned counsel for the respondents, list this matter after 2 weeks on a date 2 weeks by the Mr. Nawab, there is a fact-finding report. Fact-finding committee's report, but that is not on record.
My lord, we have stated as per the fact finding committee report that was accepted by the government and on the instruction of government, DGA is not.
I know that, but you have not paid them solicium. This is after the 2013. Solicium has not been paid. Multiplier not done.
Yes.
So I'll not pass orders, not burdening the state. Yesterday itself I have burdened
My
much.
lord, already our
Uh,
bench
to-
decision is very
Then-
clear. madam.
Then, Madam, writ appeal number 15 of 2018. 15 of 2018, na?
2000,
Place that judgment on the next day. That will be.
please.
Yes, Mr. Ratan. It seems the departments are at loggerhead. One set of department wants to pay the amount, another set says no.
My lord,
Finally, the I think the secretary or the chief secretary has said nothing doing, no payment. Then,
In fact, if my lord see,
anyway, you're here, we'll hear Mr. Purkaisto first. Yes, Mr. Purkaisto.
The only question is without whether I am covered by that notification. There are two aspects of the notification. Person died in performing duties, or one order duties, or disaster management duties. Therefore, COVID period, they said, what is their case? They said he died during COVID period, therefore he doesn't cover by that notification.
Here, COVID, no relation.
No relation. Nothing, madam. Therefore,
Yeah, only thing is, whether a person who is moving,
Yes.
not exactly on his duty, but moving for his duty,
Right.
meets with an accident and dies, whether he'll be covered by this. That's all.
That's
Show me how it is covered.
Therefore, my lord, the only question is that, my lord, if while he was returning from performing his duties, then accident took place and he died.
That maybe he had maybe 101 reasons. How
Right.
can that be
Yes.
brought under the provision of this?
Yes.
Because see, page 139, it says, it's very specific. Provide ex-gratia grant to all those state police personnel, Arunachal Pradesh police, so and so, who killed permanently disabled or grievously seriously injured while fighting terrorist militants, criminals, underground elements, or while performing law and order duties or disaster, so and so. So while in actual performance something happens,
Yes.
fine. But other than that, how can we
My lord,
saddle the government with that?
No, that
You will be entitled to all other reliefs,
But-
service benefits.
That question was dealt with by various psychologists. If a person, my lord, comes from working place to home, 5 bars of home to working place, in between if any accident took place.
That is, Mr. whether you are on duty at that point of
Yes, I
time.
was.
Here the question is law and order duty. It's
My-
not merely that you have to be on duty.
Okay.
There is something more required.
Dr. Kindly say, my lord, the report of.
There are decisions of the army personnel who have gone home
Madam.
while returning or while coming back to duty, they died
Yes.
in a railway accident or something, and then the Honorable Supreme Court has said they are on duty.
They are on duty.
There is a distinct there is another judgment which says Supreme Court the other way also.
My lord,
But here it's
Madam.
compensation.
yes,
Here this compensation has to be within 2A.
right.
You are not within 2A. At least that is the view of this court.
2A.
Page 139.
I am not 2A, but I am covered by B.
Are you sure?
While performing.
Then you have further no case.
Disaster management duty. They
You have-
said, my lord,
Further have no duty. You were not on disaster management.
my lord,
You
they
were
said-
in the border to prevent people from coming in.
No, they are saying, my lord, during the COVID period to prevent the miscreants to come from a.
Not miscreants, people
Yes,
without screening. And that is not covered. Because if you were afflicted by COVID, I have passed orders in Guwahati that you will get it. But here, I'm sorry.
my lord, okay, kindly appreciate me. My lord, it requires some, my lord, today matter has come, other days they took time. to
Okay, you
find out.
don't want to, if you want a date, I can guarantee.
Because I.
Heard Mr. Purkaisto, Learned Counsel for the petition, also heard Mr. N. Ratan, Learned Additional Advocate General, appearing for the state respondents along with Mr. T. Tagum, Learned Standing Counsel, Health.
Yes.
Also, as prayed for by Mr. A.K. Purkaisto, list this matter again. When?
On 23rd
Of this month,
August.
August, on 23/8/2024.
The other day, Doshi appreciated, it covers undamaged disaster management.
Today I'm more intelligent. That day you did not finish the matter. You should have finished the matter that day itself.
They took time.
Whoever it is. Today I'm more
Stringent.
learned.
Today, more stringent and more
Not,
educated.
not stringent, mister. When we pass an order, we'll have to be within that confines of that. I can't go beyond that. Fine, right.
Number 11 and 12.
Who is appearing for the power grid?
Your Honor, I'm appearing on behalf of Shri Nitin Khera, the Standing Council of Power Grid, Your Honor.
Yes,
Your
what do you
Lordship.
want to do? Yes.
Your Lordship, it appears that the government has filed the counter affidavit. However, we are yet to receive the copies.
Have you filed
So-
a counter affidavit here?
Yeah, we have filed, Your Lordship.
Huh?
Yes, sir.
They are filed. Okay. You have not received the affidavit filed by the government.
Yes, Your Lordship. So it seems that the
You send down your WhatsApp number to the learned council, they will, or your mail ID, they will send it to you. Okay?
So, Your Lordship,
Mr. Ratan, just have a touch. When do you want this matter to be fixed? When can you?
May I have a small intervention?
Oh.
Lordship, there has been a development in this matter.
Hmm.
Since this case was filed, I'm sorry, I have only one copy of it.
That's okay, no problem.
I have just received it, Your Lordship. It was received by the clients yesterday. Lordship, at item number 16, the petitioners have been in, if you know the series of people, the notice has gone to item number 16. The petitioners here are invited for the purpose of determining their rights. The matter, Your Lordship, concerned two issues raised by us. Number one, we were being completely excluded. Number two, as the notification was for people who have no rights and an arbitrary sum of amount, an ex-gratia payment would be given to them. So we felt completely excluded when that was read with another.
Okay, fine. When is the meeting?
That's 25th, Your Lordship. My humble submission, Your Lordship, is that on 25th, whatever list is prepared may be submitted to Your Lordship. And we have been invited in any case, so we can't proceed without.
You have brought it to my notice. I have noted it. I'll adjourn the matter. Whatever happens, happens. You bring it to our notice.
Fair enough. Your Lordship, we take this on.
Right. Okay, we'll have it after
Your Lordship, if
weeks.
may kindly on the 19th August.
Fine. Heard the learned counsel for the parties. Pleadings in the matter is complete, and accordingly, the matter can be taken up for final disposal. First up, as agreed to by the learned counsel for the parties, list this matter again on 19 August 19/8/2024 for hearing, supplementary hearing. 19/8. First up. In the meantime, if there is any development taking place in the matter, as informed by the learned counsel for the petitioner, the same would be brought on record by the parties, by either of the parties, by way of filing an additional affidavit. 19/8, Mr. Counsel. No, 19/8, you give your number to the learned counsel here. They'll send you the, by mail, they'll send you that.
All right, Your Lordship.
Sir, Ratan, do that. Give him by mail.
Number 13.
Yes, Mr. Nothing is there. Same order. Huh? Oh, same order. उसमें है. वो हमको निकाल के बोला. Dispose of. Correspondent number 4. Mr. K. Saxena, learned counsel appearing, learned counsel has submitted that he has entered appearance on behalf of the respondent number 4 in the matter, and accordingly service upon the respondents are complete. Full stop. Okay, who is for the petitioner? You know. Yes, argue. No, why? Why not you? Madam, produce the calculation sheet. They might have done some calculation somewhere. Huh? On Thursday. As agreed to by the Likhana, accordingly complete. Raised it to list this matter again on Thursday, on which date the Learned Council for the state respondents shall place before this court the manner in which the committee had arrived at the conclusion that the respondent number 4 was 4 and her family were weaker in economic condition than that of the petitioner hearing. Just get that calculation, madam. Seen the office note dated 27/2024. Service upon respondent number 4 is complete. Accordingly, raised it to list this
Lordship,
matter
in this
again.
case also I have filed my Wakalat number today.
Raised it complete. And Mr. K. Saxena has entered appearance on behalf of the respondent number 4. Accordingly, raised it to list this matter for admissions after 2 weeks.
My lordship, they haven't served us extra copies yet, my lordship.
Then raised it to list this matter after 4 weeks. So if you don't serve, what will they do? Today you serve.
My lord, this matter, petitioner have already withdrawn the EMD amount.
Already withdrawn.
Yes, no more service.
You have withdrawn the AMD amount. Nothing remains. To what? Withdraw. As prayed for on behalf of Mr. A. Shamal and a counsel for the petitioner and not objected to by Mr. J. Pawat and Mr. T. Tagum, learned counsels representing the respondents, comma, raised it to list this matter again after 2 weeks on a date to be fixed date. Not fixed date.
No.
Today was a fixed date.
Yes.
Wherever it is, you are here, you prepare.
Item number 17.
Yes, Mr. Swigert. Why was the other case withdrawn? Oh. Okay. Okay. Carried out a verification. Where is that report?
My lord, in additional affidavit filed by the grave.
So what is your decision? Are you paying him the money?
My lord, it is in
What happened to that?
additional affidavit filed by my lord,
I got it. What happened to his bills? How are his bills being processed now?
My lord, as per this joint verification report, my lord, the amount will be calculated is because this is
How long will you take? He has also said that he has submitted his bills.
my lord.
So how long will you take to come to a final conclusion?
My lord, for that, I need the instructions from the department. It's because, my lord, on the last occasion also, I pointed out this, my lord, the particular queries that why the amount is not calculated, my lord. But they have only submitted.
Heard Mr. P. J. Sekia, Learned Senior Counsel, assisted by Ms. So-and-so, Learned Counsel appearing for the petitioner and also Mr. M. Kato, Learned standing learned DY SGI appearing for the Union of India. Respondents,
1 to 4, my lord.
1 to
4.
4.
Respondent number 7.
Also heard Miss So-and-so for respond number 7 and Miss Pangu for respond number 5. Also, in terms of the directions passed by this court, it is brought on record that a joint verification was carried out with regard to the works as stated to have been executed by the petitioner herein as a subcontractor, and a report thereof has been placed on record. Full stop. The Mr. P.J. Soikia, learned senior counsel appearing for the petitioner, has submitted that in terms of the full stop, the quantity of work as executed in the matter being unbilled, right? Comma, the petitioner has submitted his bills for the purpose before the authorities, and the same is pending consideration. Mr. Kato, learned DYSGI submits that that the authorities be granted at least 3 weeks, 2 weeks time, or 3 weeks time. 2 weeks time.
My lord, since
To-
I'm sorry, my lord. Since my lord, by additional affidavit, my lord, the petitioner has filed.
No, 2 weeks time to process that and take a decision thereon, right? 2 weeks time to process the bills of the petitioner in light of the joint inspection report and pass appropriate orders thereon. The direction orders be passed, be placed before this court on the next date of listing. Registered to list this case again 2 weeks के बाद immediate 2 weeks के बाद. 12/8/2020.
My lord. Developers.
You can, nobody is stopping.
Developers.
Interim order passed earlier to continue till the next date of listing. Yes, Mr. Mo.
Your Lordship, I'm entering appearance for respondent number 2, 3, and 5 in this case today.
Okay. Your name?
T. Marngar.
T. Mannan.
For Power Grid, yes, for Power Grid Corporation Limited.
T. Mannan.
Yes, Your Lordship.
MANNAN.
MARNGAR.
Just T. M. Marvin.
MARNGAR.
Just give him the name. Okay, thank you.
Yes, Your Lordship,
Mr.
I'm
So-and-so, learned standing learned counsel appearing on behalf of the respondents number, Mr. So-and-so submits that he would be appearing on behalf of the respondent number 3,
2,
5,
3, and 5.
2, 3, and 5, and accordingly, service on the respondents is complete. Registered to list this matter for admissions after 3 weeks. In the
Your
meantime,
Lordship, may kindly have it on 19 August.
2 weeks. Full stop. The petitioners, full stop. Full stop. The respondents are at liberty to bring on record their stand by way of filing an affidavit. As agreed to by the parties, list this matter again on 19/8/2024.
Highly obliged, Your Lordship.
ये आपका जो नाम तो लिख के दे दीजिएगा. It's nice seeing you after a long time. Yes. In the present in 24/6. Why should we go into this interim business? We'll straight away go to the writ petition. Now your grievance. The challenge is now to the first was to the Annexure B.
Yes.
They have then issued a corrigendum, right?
Yes.
Now, show me why it is so illegal that we have to interfere with it.
My lord, the IU
We will dispose of the repetitions
Together.
together.
IA.
That you forget, 24th, we will take care of that. Mr. Datta's 24th, it is there. We'll take care of that on 24th. So this, what is there left, shall we? How can we say that do it in this manner, do it in that manner? Can we dictate? Who will determine whether it is reasonable from your point of view or from their point of view? If they are the employer, they are the best person to. That they have justified that we want it for this purpose. You are not ousted. You are, see, Mr. Lahiri, you are not ousted. You are not ousted. You can enter the fray, but you are not ousted. Given the calculation criteria, that is for them.
I am in the fray till a certain point of time.
Unfortunately, you don't qualify, you don't get 90. See, what error have they done? Because they have not said, see, come to page 11 of 100 and WPC 93, you are there?
93.
Page 11 of the affidavit filed by the respondents, by the one of the private respondents.
So unfortunately, I don't have a copy of that.
So we'll have all these matters on 24th then.
Together, madam.
Together. Mr. Sahiwala, you are appearing for?
Time item number 20, my lord. Today we have filed affidavit reply.
The basic question will not go into the IS. We are going straight to the issue.
I is not required.
No, we'll go straight to the issue. Satisfy me how the conditions are bad.
Yes. That
Because I am starting off with the principle, with the presupposition that the employer is at liberty to prescribe whatever he wants. But he should not oust you. And you have not been ousted.
no, we are not ousted, but ultimately I shall be ousted because they will
Ultimately, that is a different thing altogether.
No,
But
that is very important.
can this court, Mr. Sahiwala, go to that extent?
No,
That you
because
ask the government to prescribe this in this manner? We can
No,
set it
object-
aside.
But the object sought to be achieved. That is, we have to see. Because they are giving some points. The eligibility criteria is given. Eligibility criteria, we are eligible. Now, they are saying that they will get more points if they do this math. That is not a question. It is the supply of 10 crores only. Now,
So,
if they say that...
so they have said that if you have up to 20 crores,
yes.
you will have 5 points.
5 point.
And,
25.
and companies having more than 20 crores, 25 crores will have 10.
10, 20,
30
15,
crores, 15. 35 crores, 20. What error?
Suppose a tenderer, he gets 20 points here, and his rate is much higher than my rate.
That is for the employer to look at, Mr. Sahiwala.
But because we have to see what the object sought to be achieved by this. Because when I am eligible to do that work, the issuance of the tender is meaning that they will get a reasonable rate. By virtue of this, they are picking up the blue-eyed boy only. That is the...
No, Mr. Sahiwala. What had happened here was there is a particular tender which is coming up on 24th, similar matter, wherein Mr. Datta had made a challenge to this.
Yes.
And interestingly, the state has come up with an affidavit that none had qualified. So that blue-eyed concept goes. None had qualified.
In that tender, I do not know. But so far this tender is concerned, technically, I have been eligible. Now, technically qualified, I am qualified. But subsequently, by virtue of these points, I may be ousted.
So what decision would you, what decision would you like to rely upon?
I shall place it. Today I am not to that extent because we have filed the affidavit reply.
Right from NG on onwards, where we see that it's the Supreme Court now says that it's the employer who is the best man.
No, that is correct.
So when we'll have the whole writ petition for consideration, Mr. Saivala. No interim business. Direct writ petition. We'll consider the writ petition and dispose it of. When?
In, 2nd of August.
2nd of August. Okay.
12th of August.
Huh? No, the state has problem.
Station we have problem because there is an interim order operating exhaust, my lord. Why not, my lord, this 24, my lord? The one method is already fixed in 24.
7th. Everybody's convenience we see.
Yes, 7th of August.
So supplies are being made. I've looked into that also. Supplies are being made.
Some cases, my lord, temporary arrangement has been met, my lord. Some cases.
7th of August, Mr. Saivala.
Yes.
7th.
I think Thursday will be better. But 8.
Additional Advocate General appearing for the state respondents has expressed urgency in the matter in as much as in view of the stay orders, interim orders continuing in the present proceedings, the supply orders have not been in a position to be issued. Also, as for the parties, registry to list this matter again on 7th of May.
8th of May, scheduled Thursday. Hearing day.
7th August, my lord, 7th August.
7th or 8th? 7th or 8th? 7th. 7/8/2024. Push up. An endeavor would be made to dispose of the writ petitions on the set date. Interim orders passed earlier shall continue till the next date of receipt. There is no point.
Yes.
NG onwards, the decisions.
Employer. I'm dealing with it.
You allege mala fide. You have not alleged mala fide.
No, not like arbitrary.
No, nothing. Just one vague statement looks blue-eyed boys.
Yes. Anyway, I said yes.
7th of August, Mr.
8th is a hearing day, my lord.
8th is hearing day. It can be 8th.
8th is a hearing day, my lord. It will be
Mr.
better.
Ram, he wants it on 8th. Mr. 8th, no problem. 8th. Seen the office note dated 27/2024. Service report upon respondent number. Yes, what is this thing you are doing? You don't have an administrative sanction, you don't have, and the administrative sanctions in Arunachal Pradesh are given by the superintending engineers. Then why are you involving public money in this manner? Okay. The service report, seen the office note dated 27/2024, service report in respect of respondent number 4 to 7, 4, 6 and 7, 4, 6 and 7 are still awaited. Accordingly, registry to list this matter again after 3 weeks with an updated status report, with the updated report pertaining to the status of service of notice upon the said respondents. You withdraw this NITs, get your thing cleared, issue the notice. Why this? We will not, we don't want him. We don't want him. An illegality has been brought to our notice. We'll have to consider that. You don't have a technical sanction. You don't have a administrative sanction. No, administrative with nothing, and you start issuing tenders, and you have said in your affidavit that we have done it in expectation that it will come. Please have a talk with the authorities. Anyway, it is kept state. Interim order is there, so you are also not in a position to move. Withdraw those, issue afresh. Right? Interim order passed earlier to continue until further orders.
Item number 24.
Yes, what is the position now? Huh? So what decision have you taken? How long will it take? Mr. L. Prami, Learned Counsel for the Learned Standing Council Power Department has submitted that in terms of the has submitted that the committee as constituted in the matter, while the memorandum dated 22/3/2024 has submitted its report, and the same is now under consideration by the competent authority of the department. Full stop. The decision as would be required now to be taken with regard to the recommendations made by the committee as constituted by the said memorandum be so taken and placed before this court on the next date of listing. Registered to list this matter again on on 12/8/2024. Take it, finish it, that's all. ABN.
Malad, before my friend says, Malad, we will be recurring some more time, Malad. This matter is coming for the second time, Malad.
What is that?
Let that come. Two, 5.
1, 4, and 5. 1, 4, and 5.
1, 4, and 5.
Yes,
1, 4, and 5. So Mr. Namam submits that he be granted further 3 weeks' time to bring on record the stand of the respondents
Malad, instead
represented
of
by him by way of filing an affidavit in the matter. Also, prayer accepted. Registered, Mr. You have filed your affidavit.
No, no prayer.
Okay, then. Also heard Mr. D. Senapati, who is here as a tourist. Also heard Mr. D. Senapati, Learned Counsel appearing for the NIPCO authorities.
In fact, in the petition, we are just seeking that award should be made available to the beneficiary. That much prayer we have.
Oh yeah, that matter.
Yes. Only they
Yes.
can.
Sorry. I was thinking of something else. Yes, Mr. Nawab. What is that so sacrosanct document that you have kept it in your almari, not giving it to them? Wait.
Exactly.
Get your instruction by tomorrow.
Yes.
List this matter again tomorrow.
We'll try our best, Malad.
No, day after. Wednesday, on which date Mr. Nawam shall receive instructions from the Deputy Commissioner on which date the petitioners would be furnished with a copy of the award, or the award would be published in the manner required under the Upuranam Ligdina 2039.
Yes.
Wednesday, I forgot that. Sorry.
Obliged.
Day after tomorrow.
Item 26, today we are filing total 4 affidavits. The first is affidavit in opposition, which is being filed in WPC 230 of 2024. Next is affidavit.
Okay, that connected matter with
all
27.
connected. Both are connected, in fact.
28, 27.
WPC 230 is a counter blast of my colleague Mr. Diganto Das against WPC 242. So first is affidavit in opposition in WPC
I think
230.
the word counterblast is too mild. It should be something more.
Well,
When
counter
you are using it with when you're relating it to Mr. Das.
counter explosive. The first is affidavit in opposition. in WPC.
Fine. You bring it. Yes, Mr. Das.
No, nothing. What else?
But there is, he has filed today. We don't know what is there. but there is some urgency in our part, so we will look into it. If it is necessary, we'll file a reply, if it is necessary. If it is, we'll look into it. Otherwise, the matter can be fixed. The matter can be fixed.
When Mr. Tiwari is also not keeping well. So that's why the morning I was not expected to come. When?
Seventh, eighth.
Mr. Tiwari, 7th?
Seventh is seventh.
Let it be, yes, okay.
Seventh.
All right.
We'll have it together, 26 and 27 together.
It has to be, otherwise both are interlinked.
Okay, 26.
Both are interlinked. Both are interlinked.
The learning council for the parties.
Maybe take together, may not let them be judicial order.
I'm doing it today. You are filing affidavits here?
4 affidavits.
Okay.
In different.
Mr. Tiwari, learned counsel appearing for the respondent NIPCO. In
NHPC.
Item NHPC.
We are respondent in item number 26 and we are the petitioner in item 27.
Item number 26 लिखिएगा. Mr. P.K. Tiwari, learned senior counsel, assisted by Mr. Saxena, K. Saxena, learned counsel appearing for the respondent numbers 4 and 5. 1, 4 and 5 submits that affidavits on behalf of the said respondents would be filed within the course of the day. Today. Also, Mr. D. Das, learned senior counsel appearing for the petitioners, submit that they would require to peruse the affidavits so as to arrive at a conclusion as to whether a rejoinder would be called for. Full stop. The learned counsel for the parties have stated that similar matter, similar issues involved in similar to the one arising in the present proceeding is pending before this court in the proceedings of WPC number 242/2020, which is also listed today under the column apostrophe supplementary hearing. Right? So, in view of the above position and as agreed to by the parties, the present petition issue rule in the issue rule returnable by 2 weeks. Also, raised it to list this matter for hearing along with WPC number 242/2020 on 7/8/2024. Also, the petitioners are at liberty to bring on record their stand at their rejoinder to the affidavit filed by the NHPC authorities on or before 2/8/2024. Abhi ye 242. 242, you are filing some affidavit?
Yes, in 242 we have already. In 242 we are filing affidavit in reply against the affidavit in opposition of the state.
Mr. P.K. Tiwari, learned. हड्डी वो आगे वाला ही लिखिएगा जिससे इसमें खाली आपका P.K. Tiwari petitioner होगा. Learned counsel for the petitioner submits that pleadings on behalf of the petitioner in the matter is being filed today. Accordingly, Mr. D. Das, learned counsel appearing for the respondents, submit that the matter be also taken up along with WPC number 20230/2024 on 7/8/2024. Accordingly, the registry is directed to list this matter again along with WPC 230/2024 on 7/8/2024 for hearing.
Likewise, in IA 73 also, which is filed by him. IA 73 filed by him in WPC 242. We have also filed affidavit in opposition.
You bring on record.
Very
now
well.
we are only concerned with the writ petitions.
Yes, the main writ petition.
Petitions.
That's
Forget
the
the
whole-
IAs.
So,
Let the IA remain.
but ultimately, the last time also the court said, let us hear the entire matter.
That's all.
That's
Yeah,
all. We will hear.
Why it is interim
73
business?
is an IA of his application to 42.
Why it is interim
So
business?
let's hear the entire
Very
matter.
well, very well.
Can be only
So-
one prayer, my lord, if it is not inconvenient. and my learned friend, can it be on top of the hearing list, ma'am? If not inconvenient? If it is not inconvenient.
The petition, the parties are at liberty to make a mention on the next date of listing for an out of turn hearing of the matter,
I'm deeply.
for upgradation of the matter.
Yes, I'm deeply.
Make a mention. But do you think it will finish in a day? You'll be blocking the whole.
No, it's a very short point. What I felt, subject to what my learned friend, is a very narrow campus the matter is of.
May not be as narrow as my esteemed colleague believes.
Very narrow campus.
The water is very, very deep.
Huh.
Where
There
the
is-
submergence
there is
has taken, that submergence, because that's the issue, submergence.
There is a legal issue involved.
That's why I'm saying a very finer point.
Very fine.
Let's see, let's see.
Be that as it may, law will be settled on one particular.
Okay.
Item number 28 to 30.
Yes, madam.
May I please, your lordship? Lordship, ultimately, lordship, in this case, correspondence have started between Lordship, what had happened, lordship, in this case, we were given a project.
I know
lordship,
that has been
was
taken away, then now you have placed this
Yes.
that you have to get the money.
Funny.
What happened now?
Lordship, there are some correspondence which are going
So
on.
what do you want me to do today?
Lordship, some time may be given so that some negotiation may at least take place between the parties. Lordship,
Have some compassion for this court. Reading such a brief and coming and then adjournment. Okay, fine.
Lordship,
Hard day, Lanet sabka naam le lijiyega. Lanet council
Yes,
body.
sir.
We believe you. So that has not been objected to. They said there is some development of our out of court settlement. Let it be.
yes, sir.
Hard day, Lanet council body parties. Who's up? Ms. Havelia, Lanet council, and Havelia, Lanet council appearing for the petitioners have submitted that there is an discussion underway between the parties for an amicable settlement in the matter, and accordingly, she prays that the matter be taken up after 4 weeks. What's up?
Lordship, some
Uh,
date may be fixed. Lordship, first week of
4
September.
weeks, no date.
Lordship,
This time no date, because today was the date.
Lordship, because
4 weeks, date
Lordship,
date. 4
second,
weeks.
first week of September. Yes.
Prayer accepted, list this matter again after 4 weeks. Ek date de dijiye, 4 weeks.
10th September,
11.
11th September.
Can it be on 13th September? I'm at 13th September, then
11 September was.
13th September.
11.
13th.
We have taken the date of the senior advocate. We have always, all you has conveyed me that
Kitna?
after 11th of September.
11th of September. Done.
Yes, your lordship.
Done. So this is for Madam Ekman.
Yes, your lordship.
Item number 28, 29, 30.
Yes, your lordship, these 3 matters, and we can say the parties.
Mr. Chaudhary, you are for that last 2 matters. Ah, very good.
Unfortunately, my friend has a handicap. He has.
No, I'm not with your friend. Now, tell me, what is this matter?
This matter, my lord,
Was there a revision at all?
there was.
Then Mr. Purkaisu, I was suffering to find that plea. You have written so much, but you have not, only that final document shows that 4,500. So 4,500 has to be a revision. Now, what more do you want?
No, question is not there.
They have decided it in a particular manner.
No,
Fine. How can we interfere with
No,
that?
they said we are not otherwise eligible to get them allowed. Yes.
They are giving it to you notionally, right?
Yeah.
Then what more?
Notionally, my lord, our whole case is that from 1498 to,
You first gave up till 2006. You don't want areas.
my lord,
So 2006, 6 CPC comes into.
my lord.
You don't have plea here.
No, we have the.
You are from 5th CPC.
No.
4,500 is 5th CPC.
No, fifth and sixth, both the CPC. Because my lord, our claim is that we are entitled to get the benefit from 1498 to 31/3/2013. That way it covers both fifth and sixth CPC.
As per the recommendations of the 5th and 6th CPC.
Yes.
Now, 6th CPC is 9,300.
Yes.
And they are giving it to you from 13.
13.
And they are calculating that. What was the initial given to them? Initial revision of pay given to them under fifth pay CPC?
Initial.
Something was given.
Yes, yes.
Then this is the revision.
Revision. And we have
Enhanced revision.
as has rightly fallen from your lordship, we have given them notionally. And with effect from 13, they are getting it.
No, Mr. Sorry, I'm sorry. I've been trying to
My lord,
find out.
If my lord
on
will
this
kindly,
pay.
if my
Tell
lord,
me only one thing. As of 1/1/96, when the fifth CPC had come in, were they given a revision of pay?
in 9.
No, under the fifth CPC.
under the fifth CPC, they didn't give.
They were getting fourth CPC pay, something they were, say 1,000, 2,000 they were getting. That became, say, 1,500, 3,000 in fifth CPC. Were they given that benefit?
Fifth CPC.
9. My lord,
Page. Yes. They will give us.
Then you have again enhanced it.
Yes.
Say 2,000, 3,000 you have made it.
Yes.
That is what is.
my lord, what is our case?
Where, how do you say that? Anything, many material?
There are several affidavits filed.
No, but don't, I have spent enough
I'm
time.
handing over the document.
Just show me the document. No. I'm not on that. Here you see 4,000, this I have found, this document is here. 4,500, 7,000. This is the revised scale coming into being under the fifth CPC.
Yes.
Why was, okay, this is the scale given to them at that point of time?
Yes. It is the whole issue is regarding,
No.
they are simply saying that what you have given us from 2013 and you cannot give us notionally. You have to give it in actual.
No,
That is the whole claim.
No, Mr. That's just to understand that. Not being able to figure. When the fifth CPC came into being, you had implemented that. They were serving under you.
Yes.
So they were drawing a scale of pay under the fourth post. So say whether that scale was revised.
Yes, that is what is.
Because
yes.
see, here what I find is, you just see this. This is something which is missing here, Mr. Just see, fifth CPC existing revised. Have you got it?
Yes.
Existing revised.
Yes.
Next one is 6 CPC. 9,300 is 6 CPC.
6 CPC. Right.
So let's only stick to fifth. 4,500 revised to 4,500. What is that? Yes. What was the scale given to you when
My lord,
the scale was revised?
my lord, if I'm not wrong, my lord, let me not apply your lordship. Our whole case is that, my lord, whether we are entitled to get the.
Mr.
Yes, sir.
Kaisto,
My lord.
whether you were given a revised scale of pay.
No, whether we are entitled to get the, my lord, retrospective benefit. With the
So
effect
you will
of-
not answer this question whether you were given a revised scale of pay at the first stage, first instance itself.
No, not given.
Can you make that statement?
My lord, we are saying, my lord, 1,498 to, my lord, 31,313, they didn't give us anything.
This whole thing I perused yesterday, this fact I could not find out.
Lordship, what is our case? Our case, whether. we
Your
are entitled
case,
to-
Mr.
Area salary, whether we are entitled.
Purkaisto, your case I can understand.
My lord.
I understand. But why are you not answering to my query as to whether on the revision being affected under CPC,
Right.
where your scales revised?
Then I need to obtain instruction.
Why?
Because that instruction-
Why should we permit you? You have written the whole thing, everything is here. Every deprivation is here. Why this fact not brought?
My lord,
Because Mr. Purkaisto, that will have a bearing. Because if that revision was given to you, subsequently the government decide to enhance that revision as per even the decisions of the Supreme Court, that will have prospective effect only. You may not be even entitled to a notional benefit.
my lord, that.
If you have not been given a revision, I can understand.
My very clear instruction is that they have been.
My lord,
There was a revision.
Yes.
Then
my lord,
it's prospective. And why have you gone through all these exercises? Just tell them that we have given you, this is enhanced. In terms of enhanced, it will be prospective.
my lord,
In fact, my lord, when earlier the matter was remanded back, we have passed the speaking order.
No, your speaking order is also nothing. Nothing is there.
Your lordship is right.
Nothing is there.
Not happily worded at all.
You all saying big legal propositions, but the facts not even touched with. Mr. Purkhaisto has also written a thesis, but this fact not there.
My lord,
Our very specific.
our only limited, my lord, subject to my limited knowledge. Our.
You are here this week or we are going back to it?
I'm here tomorrow, but after that I have to go back.
You get that instruction, we will have it tomorrow.
Tomorrow, my lord, I will tomorrow.
From only?
Online, my lord, today, my lord, I will reach at, my lord, 2.
You want to, do you expect me to believe that you will read the brief again? Mr. Purkhaisto need not read.
My lord, that the matter
Get
will lift
that.
matter on 9th of September. I have taken the consent.
Just adjourning.
Otherwise, my lord, this question for the first time, my lord, was put to me. They did not.
I'm
raise
sorry.
it.
I'm sorry for that.
My lord, they did not raise this question. in their
Victory,
affidavit.
Ligo. Heard Mr. A.K. Purkhaisto, learned counsel for the petitioner, also heard Mr. I. Chaudhary, learned advocate general, appearing for the state respondents, assisted by Mr. T. Tagu, learned standing counsel, education department, right? Post up. The learned counsel for the Mr. T. Tagu shall on the next date this court shall receive instructions as to whether the scale of pay drawn by the petitioners prior to implementation of the recommendations of the fifth CPC, fifth Central Pay Commission in the state were revised at that juncture or not. And if, if the pay was so revised, what was the pay drawn prior to the implementation and the pay coming into effect after the revision and drawn by the petitioners or drawn by the teachers? It will be the teachers only.
Yes.
Drawn by the teachers in the state. Also, they said instruction shall be placed before this court in writing, received writing in writing on the next date of listing. List this matter again on
9th of September. Subject to his
9. He is always convinced.
He is very kind.
It's
to me.
your convenience that is required. 9.
9.
Your lordship basically wants to know whether they got the benefit of fifth CPC up.
Fifth CPC came from a particular date.
Yes.
I think it's 1196. So from 1196, they were there prior to that. They or their predecessors, whoever were prior to that. They were drawing a particular scale.
Yes.
So whether that was revised 1196.
We already have
then there might be many discussions. We got a lower pay, we want a higher pay. Then you enhance it. That enhancement you are giving from 2013 onwards. They want it from 1196. That is not permissible.
Not permissible.
That is not permissible. There are decisions.
My lord,
Please that.
my lord, what is their stand, my lord? Let me just a moment. Initially, they filed the affidavit in.
Yesterday, reading both of your stands, I was totally confused.
Lordship, kindly appreciate.
I was brought in to intervene after the force affidavit.
My lord, they initially took the plea that there was a settlement between the association and the government.
Forget it. Your affidavits
Therefore, my
are
lord,
all.
Therefore, we are going to.
One goes north, another goes west.
Therefore, you have relinquished your right. Now they are saying, my lord, we have been paid.
The whole case. What is the right?
Mr. Purkhaisto literally is off green.
Passing any order, my lord. One issue is here. My case is not only on the basis of that much. Another issue I have raised in my petition is my doctrine of legitimate expectation. Why, my lord? My lord will see here in the case, my case, my lord. My lord, question is that is it fair now? My lord will see, consider.
You hear my order, then you will know whether it is fair or not.
My lord.
Appeal. That you keep it for appeal.
My lord.
Sorry. Only boils down to that fact. Whether they have made...
Another 2 points. That is one aspect my lord has considered. My another aspect may kindly be considered. If my lord finds that this is fair on their part to change, no.
Mr. Sunar, again, you have not understood. What I have examined is what they have done. Whether they had prepared a select list. If that select list is on record, then the subsequent action will be of no consequence.
And my lord, on point, my lord, if we say that select list, my lord, basically select list has. Here is the case,
Committee has prepared it.
Let's assume it has been prepared.
Huh.
My lord will see from the, my lord, admitted position is that, my lord, from the 1997, 2000, 2006, 2007 batch, my lord, our earlier batch. All the-
They made a mistake. Now don't kill them for that.
My lord, this is why this. The legitimate expectation, how it arises is. my
Okay,
lord,
fine. We'll consider. But Mr. R. Sonal, learned counsel for the petitioner, and also Mr. Tapin, learned the senior government advocate, appearing for the respondents number 1 to 5. Who nobody appears for the private respondents?
No.
See, they are so confident.
my lord,
First off, the petitioner, by way of instituting the present proceeding, has presented a challenge to a gradation list as published for the seniority list as published for the gradation list of SKB, gradation list as published for the post of LDC/SK in the Water Resources Department as on 3/11/2009. Full stop. As projected in the petition, the petitioners were recruited on direct recruitment basis to the post of LDC in the year 2002. Full stop. The petitioners in pursuance to a process of selection were appointed as LDC along with the private respondents herein, while issuance of a order dated. What is your appointment order date? Order dated 27/3/2002. Full stop. The petitioners contend that after having joined their services, no gradation list was ever brought to their notice. However, on a promotion being effected to the cadre of UDC of one, what is her name? Nungri Santi.
my lord.
No, the person who was promoted, Tagenenka.
Tagenenka.
When a promotion to the post of so-and-so was so made, UDC was so affected in respect of the respondent number 11 herein, the petitioners made enquiries and had come to learn that the said promotion was so affected in respect of the respondent number 11 on account of she being shown to be senior to the petitioners herein in the gradation list as published by the respondent authorities of the incumbents in the cadre of LDC/SK as on 3/11/2009. Also, being aggrieved, the petitioners have instituted the present proceedings, presenting a challenge to the gradation list as well as the promotion effected in respect of the respondent number 11. Also, Mr. Sona, learned counsel for the petitioner, submits that in terms of the provisions of the rules holding the field, that is, the Arunachal Pradesh Secretariat Subordinate Service Rules 1989, the appointments are to be effected from the select list in order in which the names appear in the list. In term of submits that refers kya likha hai? Mr. Sona refers to the provisions of the Arunachal Pradesh Secretariat Subordinates, contends that in terms of the provisions of the Arunachal Pradesh Secretariat Subordinate Service Rules 1989, more particularly Rule 14 and 18 thereof, the appointments are to be effected from the select list in order in which names appear in the set list. So, Mr. Sona, by referring to the order of appointment dated 27/3/2002 has contended that the names of the petitioners in the said appointment order are placed above that of the private respondents, and accordingly, following the prescription as made in the said rules of 1989, the petitioners herein are to be deemed to be senior to that of the private respondents. Also, Mr. Sona further contends that the merit position of the petitioners would be evident. Merit position of the petitioners in the connected selection process would be evident from the appointment order and the placement of their names therein. Also, it is contended that the names of the present petitioners are placed at serial number 2, 3, 4, 5, and 15 of the order of appointment dated 27/3/2002, which, according to Mr. Sona, reflects the merit position of the petitioners herein. Accordingly, Mr. Sona submits that the inter se seniority position as assigned to the petitioners in the impugned gradation list would call for an interference from this court, and accordingly, and further, the appointment as made in respect of the respondent number 11, promotion as made in respect of the respondent number 11 herein would also call for an interference. Okay. Mr. Tapin, Learned Senior Counsel, appearing for the state respondents by referring to the contemporaneous records maintained in the matter, has submitted that although the selection committee had prepared a select list in terms of the merit of the persons participating in the selection process, however, while publishing the select list, wide care date, what is the date? That loose paper. Dated
27 March 2022.
While publishing the select list, while order dated 27/3/2022, the same was so published, maintaining the seriatim of the roll numbers of the petitioners found selected, name numbers of the applicants found applicants selected for appointment against the post of LDC/SK. Also, Mr. Tapin, by producing the relevant records, has impressed upon this court that the gradation list as prepared in the matter for the incumbents in the cadre of LDC/SK as on 3/11/2009 was so prepared strictly adhering to the merit of herein, as well as the private respondents were assigned seniority positions in the impugned gradation list strictly in accordance with the merit position as obtained by them in the connected selection process. Accordingly, Mr. Tapin submits that there being no violation of the provisions of the rules of 1989, this court would be pleased to reject the contentions, to dismiss the writ petition. I've heard the learned counsel for the parties and also peruse the materials available on record. At the first blush, on perusal of the order of appointment of the petitioners as well as the private respondents dated 27/3/2002 on being considered along with the provisions of Rule 14 and 18 of the said rules of 1989, it would be, it could be presumed that the petitioner's placement in the order of appointment dated 27/3/2002 was so done basing on the merit position obtained by them in the connected selection process. Also, however, on perusal of the records as produced in the matter by the respondents through Mr. S. Tapin, learned senior government advocate, it is revealed that the selection committee as constituted for the matter had prepared a select list basing on the marks scored by the persons appearing in the selection process, and thereafter the decision was arrived at to appoint the person so selected after providing for the reservations involved. Also, subpart. When the select list in question was so published, widely notice dated 27/3/2002, however, while publishing the said select list, the merit position obtained by the select list, the roll numbers involved were not so published by reckoning the merit position obtained by the candidates selected. Also, the set this was so prepared by placing the roll numbers of the selected candidates in seriatim from the lowest to the seriatim in a ascending order. Also, this court, ascending order, subpart. This court, having perused the records and being convinced and having found that the select list in question was actually prepared and the seniority positions as assigned to the petitioners as well as the private respondents hearing in the impugned gradation list confirming to the merit position obtained by them in the connected selection process, comma, this court is of the considered view that the impugned gradation list would not call for. To be noted that the petitioners in the writ petition had brought on record a statement pertaining to the marks obtained by the petitioners as well as the other recruitees of 2002, right? However, while bringing the said statement on record, the petitioners herein have not disputed the marks stated to have been scored by them and the other recruitees of 2002. Also, the said position having been accepted by the petitioners and the seniority positions, even from the set statement prepared by the respondents, by the petitioners, having revealed to have been so done, basing strictly on the merit positions as obtained, marks as obtained by the applicants in the direct recruitment process of 2002, comma, this court is of the considered view that the seniority positions were so assigned to the batch of 2002, including the petitioners and the private respondents herein, basing on the merit position as obtained by them in the connected selection process, leading to their appointment, while the order of appointment dated 27/3/2002. Also, in view of the above conclusions with regard to the challenge to the gradation list of, to the challenge to the impugned gradation list, comma, this court is of the considered view that the promotion as effective therefrom in respect of the respondent number 11 would not call for any interference. Also, in view of the above conclusions, the gradation list impugned in the present proceedings as well as the promotion effected in respect of the respondent number 11 would not call for any interference, and accordingly, the writ petition having been found to be devoid of any merit, the same stands dismissed. However, there would be no order as to cause. I have only said you have not disputed that.
No, my lord, I have disputed. That's why, my lord, if my statement also, I have said this is a forged and this document false and fabricated. And my lord has relied on chart. I said purported mark. I have not said that.
Because that is now confirmed by the.
This is another case. Another aspect my lord has not considered. Assuming that that is the mark, law says, my lord, reasonable expectation is there. When by your conduct, you are letting me to believe for 7 years.
Okay, show me a gradation list published prior to this, wherein your names are in the top.
My lord,
I'll score off this order. Show me a gradation list published prior to this, because gradation list has to be published every year.
Not published there.
Then published. Then
Yeah, lawsuit. Petitioner was never treated as senior to them, lawsuit. Because he was never made to understand law. He has been
understand.
treated as senior, lawsuit.
Mr. Sunar's grievance is
Till
also,
2009, lawsuit.
that is because Mr. Sunar's grievance is because of the inaction on your part. You ought to have made this position clear. That see, the select list that we have published is one not on merits. Today, it is being revealed. You had never revealed that. One. Two, they were working for 7 years. But you have not published a single gradation list for 7 years.
7 years.
After 7 years, you promote somebody, you want to promote somebody. Now that you have managed it, we know we are not going into that. But the grievance of his is genuine.
Lawsuit for this 7
My
years.
case is basically, my lord has not reflected my case in true picture. Only one aspect my lord has considered. Other aspect my lord may be considered.
I
May
cannot.
pass any order, but my case may be considered.
What is your case? What do you want?
My case is, my lord. Yes, my lord. That aspect, my lord, may pass any order, my lord. But at least my
Okay,
case,
tell me what it is.
yes, my lord. My basic case is, my lord, that in respect of, my lord, here is a, my lord, in respect of this appointees of 1997, 2000, 2006. My lord,
Paragraph.
let me complete
I got it. Mr. Sonar,
my lord, let
Learned
me
Counsel
complete.
for the petitioner submits that the department had been consistently following the provisions of Rule 14 and 18 inasmuch as the direct recruitees of the year 1997,
2000,
2000,
2006,
2006,
2007.
2007 were
As per the appointment order.
were appointed in order. The क्या लिखा है?
Seniority given as per the appointment order.
Victoria. Were assigned seniority positions in accordance with the placement of their names in the connected appointment orders.
My lord.
Full stop. However, without any reason being assigned, the said procedure consistently followed by the department has been departed in the present case.
Only in 2000, yes, my lord.
Has been departed in case of the petitioners here. Okay.
And my lord, we have an expectation since the same process you have been following for 7 years. I have been expecting that this is
Mr. Sonar, Mr. Sonar, I cannot base my decision on one side. I have gone through the records. Thereafter, I have done it.
But the law says legitimate expectation says, my lord, if a old practice give you consistently a reasonable expectation, it is.
There is a
unclear.
latest decision of the Supreme Court. Just go and see that.
I have seen.
What is that legitimate expectation?
If
Okay.
my lord,
Can't help it.
My lord. Deeply obliged.
Heard Mr. R. Sona, learned counsel for the petitioner, also heard Mr. Who is appearing for the respondents here? Ms. G. Ate appeared, I suppose. Huh?
No, I think standing counsel.
Standing counsel. Phone, eh? Who is it? Who is it? Huh? Agriculture. Horticulture.
Gatso, Mr.
Gatso.
Gatso was it?
Yes, also. The petitioner has, by way of instituting the present proceeding, presented a challenge to the where is Annexure 5? By way to a notification dated 23/10/2007, by which, basing on the recommendation of a board, the
My lord, before passing order, one order may kindly be seen, my lord, passed by this honorable Justice K.R. Surana, my lord.
Yes,
Where
sir.
it says, my lord, this report.
by which the respondents number 5 to 10 were selected for arranging supply of input incentives to beneficiaries under MIDH and other horticulture schemes under the District Horticulture Officer, East Coming District for the year 2017-18. Also, the petitioner has also presented a challenge to an impugned to a work order dated 13/12/2017, by which the respondents number 5 to 14 were issued with such supply orders. Also, Mr. Sona, learned counsel for the petitioner, has at the outset submitted that the very process as adopted by the respondents herein to select firms and thereafter issue supply orders to such firms is clearly contrary to the scheme involved, inasmuch as the scheme as involved in the matter requires the authorities to transfer the amount involved to the beneficiary, who would then be at liberty to buy the implements so requisite from a shop, from a trader having the said implements. Also, it is contended by Mr. Suna that the respondents number 5 to 14 do not have the expertise as mandated under this scheme, and they also do not have a fully operational showroom for the purpose of facilitating beneficiaries to come and buy the implements required, inputs required, and accordingly it is contended that the supply orders issued to the respondents number 5 to 14, in addition to being in violation of these provisions of the scheme, of the scheme, comma, is also not sustainable, in as much as the said respondents number 5 to 14 are not eligible for being issued with such work orders. Also, accordingly, Mr. Sona submits that this court would be pleased to interfere with the work orders as issued in the matter in respect of the respondents number 5 to 14. Also, no affidavit has been filed.
No affidavit.
Also, the learned, no, there is an affidavit. The learned counsel appearing for the learned standing counsel appearing for the Horticulture, the Directorate of Horticulture has submitted that the grievance of the petitioner in pursuance to orders passed by this court were so inquired into by a committee constituted in pursuance to the directions passed by this court while order dated 4/1/2018. Right? Committee was from 4/1/2018.
Yes, yes.
Full stop.
Committee was constituted by order 31st.
No, 4/1/2011, so and so, so and so, so and so. No matter accordingly. 31st, where is that?
31st February 2018, madam. It seems from the inquiry report.
31st February.
Yes. Order is 4 January 2018. Passed by this.
That's it. Full stop. The Learned Council for the Learned Standing Council for the Horticulture Department has placed before this court the inquiry report as inquiry report of the committee as constituted by this court while they said order dated 4/1/2018. So, I've heard the Learned Council for the parties and also perused the materials brought on record. So, the issue as the grievance as raised by the petitioner in the present proceedings, having been required by this court to be inquired into by a committee constituted by it, comma, a perusal of the report of the said committee would be called for. So, the said committee has submitted its report on 12/4/2018. So, the committee, upon a due examination of the grievances as raised in the matter by the petitioner, in the writ and also the allegations raised in the writ petition, proceeded to have a site visit to examine the showrooms/shops of the petitioner as well as the private respondents herein. On a such visit being conducted on 4/4/2018, the committee in its report observed that the shop of the petitioner had the maximum quantity of various agri/horti inputs displayed. However, with regard to the shops of the respondents number 5 to 14, the committee was of the view that some of the shops had a few quantity displayed, whereas the majority of the other shops were found closed or with no agri/horti inputs available. So the committee thereafter, basing on the statements made, thereafter examined the concerned authorities, including the then District Horticulture Officer SEPA. So the District Horticulture Officer SEPA had in his statement made before the committee contended that the supply order of agri/horti inputs were issued to 11 firms based on recommendation of a board and as per provisions of para E of the guidelines for implementation of DBT and HOTNET, HORTNET, issued by the Commissioner Horticulture, Government of Arunachal Pradesh, wide memorandum dated 23/5/2017, as the beneficiaries involved had expressed their inability in procuring the inputs by themselves and had authorized the District Horticulture Officer SEPA to procure the inputs on their behalf. Also, it was further stated by said District Horticulture Officer SEPA before the committee that the inputs were procured and issued for distribution to the actual beneficiaries through field functionaries at various levels. Also, The district horticultural officer had also further submitted that the petitioner firm was issued with maximum amount of supply order among the selected firms and selected firms, however, the said firm having failed to supply the inputs within the stipulated time, the supply order so issued to the firm, petitioner firm, was cancelled and issued to some other firm from amongst the firms recommended by the board concerned. The report further proceeds to note that the supply as involved in the matter was completed and the same as furnished to the actual beneficiaries. So it was further held that the payments against the supply of the inputs were already released to the various firms through online bank transfer in their respective bank accounts on 3/1/2018. So in view of the said materials coming on record, the inquiry committee, although has contended that there has recorded that there were some procedural lapses in selection of firms who did not have proper showroom /shops of agri/horti inputs, which was an essential requirement as per circular issued by the district horticulture officer dated 29/2017. However, the committee took into consideration that the board as constituted in the matter had empaneled the said firms, keeping in view the larger interest of struggling entrepreneurs as there was a lack of self-employment opportunity in the East Kameng district. Also, as regards the other allegations of the petitioner, the committee had on consideration of the same rejected it. Also, however, the committee recorded lack of awareness regarding the direct bank transfer bracketed DBT process even amongst the field staff of the department. The committee on conclusion of the discussion on reaching the said conclusions made the following recommendations. Page 5, A to A. ये नंबरिंग नहीं है, ये ग्रीन मार्क है. Also, having considered the report of the said committee, this court is of the considered view that the supply orders as well as the supplies made having been so effected and completed and the payments thereon made to the concerned firms, and the petitioner firm also being issued with supply orders for a substantial quantity involved, given the fact that the inquiry committee had not found anything adverse against the departmental authorities and or the firms involved, this court at this distant point of time would not like to reopen the matter, which has already been settled way back in the year 2018. Also, accordingly, the contentions raised by the petitioner in the present proceedings is not accepted. Also, however, noticing that the inquiry committee had made some recommendations in the matter, which has been noted here in above. The departmental authorities are directed to strictly adhere to the said recommendations, comma, provided the same scheme is still in operation as on date, comma, as and when the said schemes are implemented in the district concerned. First, with the above observations and directions, the petition stands disposed of. Because therein it is said that next time you do it in the DBT manner. So we'll do it. Now, how can you, being a writ court, 18 matter, now I say, no, you are not entitled.
Here, interesting here in better, they have not filed affidavit, bringing on record like when payment was done, because now what they are doing, because on 4th one, my lord, status quo was issued.
3-1, they say.
So
bank
they are
has-
now only statement, my lord. Nothing is there. Supporting document.
Mr. Sunar, well, it's not 7 months that I have come from there to here. I can understand that well, but can't help it.
Well,
thank you.